You trust the system, to be fair, right? But what actually happens when the people running it, the judges, the prosecutors, lawyers, are the ones gaming it?
Well, it's a terrifying thought, but it's exactly what we're looking at today.
Right. Today we're diving into this exploration of the source material titled Justice Betrayed, A Guide to Dereliction of Duty. And our mission here is to really figure out that razor-thin line between an honest human mistake and an actual criminal betrayal of the law.
Because let's be honest, in a high-stakes environment like a courtroom, people are definitely going to mess up. It happens.
Yeah, of course it does.
But what's fascinating in these sources is how the law distinguishes between just bad work and an actual crime.
Yeah.
And it's based almost entirely on what's happening inside the person's head.
Okay, so let's unpack this, starting with the person in the robe. If you're sitting in a courtroom and the judge makes just a wild call against you, how do you know if they're just out of their depth or if they're actually
breaking the law?
Right. So it comes down to something the sources call the malice threshold. Looking at Articles 204 through 206, a judge is only legally liable for an unjust judgment if they have a conscious, deliberate intent to do an injustice.
So if they just make a mistake, maybe they misinterpreted a really dense, confusing statute,
then that's an erroneous judgment. If it's made in good faith, it's not a crime, it's just a reversible error.
Wait, though, that sounds incredibly subjective. Couldn't a judge just claim they misinterpreted everything? Like, oops, I didn't mean to be unfair?
Not quite. The law actually has a built-in BS detector for that.
Oh, really?
Yeah, it's the manifestly unjust standard. If a ruling is so clearly wrong that even someone with what the sources call meager legal knowledge can see the injustice, the law assumes inexcusable negligence. Basically, you can't claim good faith if you ignore the absolute basics of the law.
And this isn't just for the final guilty or not guilty verdict, right? Exactly. It applies to interlocutory orders, too. Think of those as the mid-game decisions a judge makes before the final whistle. If those are knowingly or negligently unjust, the judge is still on the hook.
Okay, so intent is the judge's shield. But what about the people on the front lines, the officers of the law? The guide defines this pretty broadly, though I noticed it specifically excludes internal revenue officers.
Right. Tax collectors have their own separate rules to play by. But for everyone else who is duty-bound to prosecute, Article 208 outlines two main forms of dereliction. First, maliciously refusing to prosecute a crime they know is about to happen.
And the second,
maliciously tolerating people they know are already breaking the law.
And the stakes here actually shocked me. If an officer helps a criminal escape, the law doesn't just call them an accessory. They are treated as a principal in the crime.
Which means they're essentially viewed as just as guilty as the person who committed the original act. It's a heavy-handed approach because they are betraying the public trust. Again, it all hinges on the intent to favor the criminal.
Which brings us to the clock. Missing deadlines. The sources outline a clear distinction under Article 207 between malicious delay and delay without malice.
And this is where the law gets very realistic. Malicious delay is stalling specifically to cause harm or hinder justice. Delay without malice might just be incompetence or a lack of diligence.
So both get penalized, but the intent drastically changes the severity of the punishment. It's the difference between being a bad employee and being a criminal. Let's shift to the person you actually hire to protect you, your own lawyer.
Right. The advocate. The guide says they can be liable for inexcusable negligence or ignorance if it causes the client damage.
Because if you're hiring a lawyer, you're handing them the keys to your life. The law ensures they can't just drive that car off a cliff.
Precisely. And there's a specific prohibition against double dealing. A lawyer can't undertake a defense for the opposing party without your consent. It's all about ensuring your advocate is 100% in your corner.
But then there's the secret rule, which really stood out to me. Usually, to win a case against someone, you have to prove their actions actually hurt you.
But not here. If a lawyer reveals your professional secrets, they can be punished, even if no actual damage is proven.
Because the betrayal of trust itself is the crime, regardless of the outcome. It means your lawyer can't just go to a cocktail party and spill your secrets, even if it doesn't technically ruin your case.
Exactly. It's a very high bar for gossip.
So connecting this to the bigger picture, it's clear the law recognizes that the system is run by humans. Humans make mistakes. But there's a clear line where human error becomes a deliberate betrayal of duty.
And these laws exist to ensure the massive power we give to judges and lawyers isn't turned into a weapon.
It's a lot of weight to carry. I'll leave you all with this final thought. If a lawyer reveals a secret that actually ends up helping their client's case in the long run, should they still be punished? The law says yes, because the betrayal is the crime. But does the good outcome change how you feel about the ethics of it? Something to mull over. Thanks for joining us for this exploration. We'll see you next time.
Welcome to The Explainer. Let's talk about something kind of scary. What happens when the very people we trust to uphold the law are the ones breaking it? Today, we're diving deep into the ultimate betrayal, dereliction of duty. And this is a huge question, right? The whole system is built on trust and fairness. So what happens when that trust just shatters? We're going to get into the nitty-gritty of where the law draws the line between a bad day at the office and an actual crime. Okay, so what are we really talking about here? At its heart, dereliction of duty is when an official completely drops the ball. And I don't mean they just mess up. We're talking about a failure so big, so profound, that the law itself calls it a crime against the public. It's a betrayal of the oath they took. All right, let's kick things off. Where do we start? Well, let's go right to the top of the food chain, the judge, the person in the black robe with the gavel. Their power is immense, right? They can literally change the course of a person's life. But, and this is a big but, that power isn't unlimited. There are some serious checks and balances in place. And right off the bat, you can see the law splits this into two big categories. It really all comes down to what was going on in the judge's head. So in one corner, you've got a judge who knows their ruling is unjust. This is deliberate, intentional wrongdoing. In the other corner, you have a judge who makes a decision that is just so spectacularly wrong, it could only happen because of some truly inexcusable carelessness. So if you want to actually convict a judge for a knowingly unjust judgment, you got to prove all four of these things. 1, they're a judge. Easy enough. 2, they made a judgment. Check. 3, the judgment was unjust. Okay, provable. But number 4, proving the judge knew it was unjust? Whoa, that's the mountain to climb. How do you prove what's inside someone's head? It's an unbelievably high bar. And check this out. This is where it gets really interesting. The courts have basically said, hey, it's not even enough to prove they knew it was wrong. You have to prove there was a conscious and deliberate intent to do an injustice. Just let that sink in. This means an honest mistake, even a really, really bad one, is not a crime. The law isn't going after judges who are just bad at their jobs. It's going after judges who are corrupt. Okay, so what about the other side of the coin, the negligence one? Well, for that, the ruling has to be manifestly unjust. And that's not just legal jargon. It means the decision has to be so blatantly, ridiculously wrong that literally anyone, even someone who's never set foot in a law school, could look at it and say, nope, that's not right. We're not talking about splitting legal hairs here. It has to be an absolute, in-your-face injustice. And it doesn't stop with the final verdict either. A judge can get in hot water for bad rulings they make in the middle of a case. These interlocutory orders. Or, and this is a big one, for maliciously delaying things, like purposefully dragging their feet on a case just to mess with someone. You've heard the saying, justice delayed is justice denied, right? Well, in this case, it can also be a straight-up crime. Now, judges are powerful, for sure, but they can't just pluck cases out of thin air. A case has to be brought to them by a prosecutor. So you can think of prosecutors as the gatekeepers of the justice system. They decide who gets in. So what happens when the gatekeeper just decides to keep the gate shut when they shouldn't? This is where Article 208 comes in, and it's a huge deal. It basically says that if an official, we're talking prosecutors, police chiefs, you name it, deliberately turns a blind eye to a crime they know is happening, they themselves can be charged with a crime. It's the law's way of saying you can't just look the other way. And look, here's that theme again, malice versus mistake. It's so important. A prosecutor has to make judgment calls all the time. They might look at a case and think, you know what, the evidence just isn't there. That's not a crime. That's just doing their job. But it becomes a crime when there's malice, when they look at a strong case and decide, I'm going to bury this, with the specific intent of letting a guilty person walk free. That's the betrayal. All right, so we've talked about judges, we've talked about prosecutors, but there's a third crucial piece to this puzzle, the attorney. Now, their duty isn't to the government or the public, it's 100% to their client. That relationship is sacred, it's built on a foundation of absolute trust. And believe me, the law takes protecting that trust very, very seriously. Yeah, check out Article 209. When a lawyer betrays their client, it's not just a slap on the wrist from the Bar Association. It can be an actual crime. We're talking about some serious stuff here, like being so negligent you completely tank your client's case, or spilling confidential secrets your client told you in private, or, and this is the big one, turning around and representing the other side in the same case. Just, wow, that's the ultimate betrayal. So you see the pattern, right? Whether we're talking about judges, prosecutors, or lawyers, it all boils down to the same thing. There's this razor-thin but absolutely crucial line between a simple human mistake and a malicious criminal act. When you lay it all out like this, the picture becomes crystal clear. For every one of these roles, the law sets a really, really high bar to prove a crime. It gets that these are tough jobs and people make mistakes, so it's not punishing errors in judgment. To cross over into criminal territory, your actions have to be knowingly corrupt, truly malicious, or just so shockingly careless that there's no other excuse. And that is why this all matters so much. These laws are basically the system's guardrails. They're there to stop the abuse of power and to make sure that the whole structure doesn't come crumbling down. They send a crystal clear message. It doesn't matter if you wear a robe or have a badge, nobody is above the law. But, it's one thing to have these laws written down in a book. It's a whole other thing to actually enforce them, right? How do you make sure these checks and balances actually work in the real world? That's a big question, and maybe a story for another time. But it's the most important question of all when you think about what it takes to protect justice itself.
Welcome back to the deep dive. I want to start today with a feeling that I think we have all had at some point.
Oh, absolutely.
Yeah, you know the one. You're driving, maybe going a little bit over the speed limit, and suddenly you see a police car in your rearview mirror.
Your heart just jumps.
Right, it jumps. Even if you aren't doing anything wrong, there is this sudden, intense awareness of power.
You realize in that split second that the person in that car can completely ruin your day.
Cost you money, tow your car, or worse. Now, I want you, the listener, to take that exact feeling and magnify it by 1,000.
Easily 1,000.
Imagine you're standing in a courtroom. Your freedom, your reputation, your entire financial future is quite literally in the hands of one single person sitting up on a raised bench.
It really is the ultimate vulnerability, isn't it? We surrender so much of our autonomy to the justice system.
We do. We basically say, here are the rules we all agree to live by, and here are the people we trust to actually enforce them.
But that trust, it relies on a very fragile assumption. That the people in charge, the judges, the prosecutors, your own lawyers, are actually the good guys.
Right. But what if they aren't? I mean, what if the judge is just blatantly corrupt?
Or the prosecutor is incredibly lazy.
Or what if your own defense attorney is secretly selling you out to the other side?
The Roman poet Juvenal, he actually asked it best centuries ago. He asked, quis custodiet dipsos custodes?
Who watches the watchman?
Exactly. Who watches the watchman? It is a question that has basically plagued human civilization since laws were first carved into stone tablets.
Because if you give someone the power to punish people, you have to have a mechanism to punish them when they abuse that power.
If you don't have that, you don't really have a justice system. You just have a tyranny of the enforcers.
So today, we're going to find out exactly how that accountability mechanism works, or, how it doesn't work. We're doing a deep dive into dereliction of duty.
Specifically focusing on Chapter 2 of the source material.
Right, malfeasance and misfeasance in office. We are looking at the specific crimes in the revised Penal Code Articles 204 through 209, for those following along, that are explicitly designed to catch the people who are supposed to be catching criminals.
And we really need to clarify something right up front here.
Yeah.
We aren't just talking about ethical violations today.
Yeah.
We aren't talking about a judge getting a stern talking to from the Bar Association because he was rude to a witness in court.
No, we are talking about actual crimes. Felonies.
Situations where the judge or the police chief becomes the one wearing the handcuffs.
The source material for this deep dive it's just fascinating because reading through it, it feels like a high wire act.
It really is a balancing act.
Because on one side, you have the absolute public need to punish corruption. But on the exact opposite side, you have this desperate systemic need to protect the independence of the courts.
Right, because if you arrest a judge every single time they make a factual mistake, the whole system just instantly collapses. No one would ever want to be a judge.
That is the central tension we are going to explore today. We're going to look at the massive gap between being bad at your job and being a criminal.
Because in the eyes of the law, those are two incredibly different things.
So we have a stack of case law, we have the revised penal code provisions, and we have our mission to figure out when doing a terrible job actually becomes a literal crime.
Let's start right at the top of the food chain then.
The judiciary. Segment 1, let's look at Article 204.
Article 204.
The title of this article is Knowingly Rendering an Unjust Judgment.
Just the title alone has some serious weight to it.
It sounds so ominous. It sounds like something a villain does in a movie while twirling his mustache. I shall knowingly render an unjust judgment.
Well, it is considered the most serious offense in this entire chapter, and that's because it strikes at the very core of why we even have judges in society.
Right.
If a judge decides a case incorrectly on purpose, the justice system is essentially lying to the public. It breaks the social contract completely.
Let's break down what that actually means in practice, though. Because the word unjust, it feels really subjective to me.
How so?
I mean, if I get sued and I lose, I'm going to go home and complain to my family. That judgment was totally unjust.
Of course. Nobody likes losing.
But me feeling like it's unjust doesn't mean the judge committed a crime.
No, it doesn't. Your personal feelings don't matter here at all. The law, specifically referencing the notes from the Reyes syllabus and the case of Santa Maria versus Ube, it sets a very objective standard.
Okay, lay it out for us.
A judgment is legally unjust if it is contrary to law or if it is not supported by the evidence presented.
Okay, so let's play this out with a hypothetical so we can really see it. Let's say the law says car theft is punishable by prison.
Okay.
And the evidence in court clearly shows, beyond a doubt, that John stole the car. But the judge bangs his gavel and rules John is completely innocent.
Right. That judgment is unjust because it flatly ignores the evidence that was submitted.
Or, to flip it around, what if the evidence shows John stole the car, but the judge rules John is sentenced to death?
That is also an unjust judgment, but for a different reason. That one is unjust because it is contrary to the law. The penal code doesn't allow the death penalty for stealing a Honda Civic.
Makes sense. So the first step is proving the decision was objectively, measurably wrong.
Yes, but, and this is the crucial part, being wrong is not a crime.
Thank goodness, or every weatherman in the country would be serving a life sentence.
Exactly. And that is where the knowingly part of the title comes into play. This is where this deep dive gets really sticky for the prosecution.
Because it's not enough to prove the ruling was bad.
Right. The element that transforms a bad legal ruling into a felony is the internal state of mind of the judge. The offender must actually know that the judgment is unjust when they render it.
I really want you, the listener, to stop and think about how incredibly hard that is to prove in a real courtroom. You literally have to prove what was happening inside another human being's brain at the exact moment they signed a piece of paper.
It is the ultimate psychological hurdle in criminal law. We call it mens rea, the guilty mind. And for judges, the bar to prove it is incredibly high.
The source material cites a case that I think really illustrates this perfectly. U.S. versus Gakutan.
Yes, the Gakutan case is a perfect example of this tension.
I was reading through the notes on this one.
Yeah.
This is the case where the judge actually got it totally wrong, right? Like, objectively made an unjust judgment.
He did. The facts were very clear. The judge rendered a decision. A higher review body looked at the case file and said, this is wrong. This is an objectively unjust judgment.
So the first three elements of the crime were totally met. Offender was a judge, check. Case was submitted, check. Judgment was unjust, check.
All met.
But he walked free.
He was completely acquitted.
Why?
Because the prosecution could not prove, beyond a reasonable doubt, that he knew it was unjust at the time he made it. The appellate court essentially looked at it and said, yes, he made a terrible, terrible call, but maybe he just made a mistake.
That feels like a massive get-out-of-jail-free card for any judge. You can just throw your hands up and say, oops, I didn't know. How do you ever overcome that defense?
It's extremely difficult.
Do you need a physical diary entry? Where the judge writes, Dear Diary, today I plan to completely ignore the law and frame an innocent man.
You almost need something exactly like that. You need what the Santa Maria versus Ube case calls conscious and deliberate intent to do an injustice.
And how do you show that without a confession?
Usually that means you need to prove a strong external motive, a motive that makes the I just made a mistake defense completely impossible for any reasonable person to believe.
Like bribery.
Bribery is the absolute classic example.
So if we can prove you took $50,000 in a duffel bag from the defendant.
Right. If you take the money and then you render a weirdly wrong judgment in favor of that exact defendant, the court is going to infer that you knew it was unjust. You clearly did it because of the money.
What about personal grudges?
Personal ill will or revenge absolutely counts.
So if the defendant standing in front of the judge is the guy who dated the judge's daughter and totally broke her heart.
Exactly. If the personal connection is that intensely negative, the reviewing court can look at the bad judgment and say, no reasonable, impartial judge would make this specific error. The only logical explanation is malice.
Okay, I see.
But, and I cannot stress this enough, if there is any room for a reasonable difference of legal opinion, the judge is going to get the benefit of the doubt.
I guess I understand the logic behind that. You really don't want judges looking over their shoulders constantly second-guessing themselves out of fear.
Right.
If I'm a judge and I'm looking at a really tricky, unprecedented case, and I know that if I interpret this weird new law one way and the Supreme Court eventually disagrees with me, I might go to actual prison.
You'd be terrified to rule.
I just refuse to take the case. Or I just always do whatever the prosecutor wants just to stay safe and avoid controversy.
Precisely. In the legal world, we call that the chilling effect. We desperately want judges to be independent thinkers. We want them to have the courage to make unpopular decisions if that's what the law genuinely requires.
Even if the public is screaming at them.
Exactly. And the price we as a society pay for that judicial independence is that we have to tolerate some honest errors.
There's another case in the notes that makes this explicit, right?
Yes. Yarinen versus Judge Rubio. The ruling there is very clear. An error of judgment is not a crime in the absence of bad faith, ill motive, or improper consideration.
So if I'm understanding this correctly, Article 204 is really just for the actual villains.
Yes.
The corrupt, the vengeful, the people who are actively, maliciously weaponizing the bench for their own gain.
That's a great way to summarize it.
But what about the fools?
The fools.
Yeah, the fools. The judges who aren't evil, they aren't taking briefcases full of cash, they don't have personal vendettas, they just didn't study for the bar exam very hard. They are lazy, or they don't keep up with the new laws being passed, and they are just terrible at their jobs. Surely at some point, sheer stupidity becomes a crime, right?
That brings us perfectly to segment 2 of our deep dive, Article 205.
Okay. The title for this one is Judgment Rendered Through Negligence.
This is the exact flip side of the coin we were just looking at. Article 204 requires active malice and evil intent. Article 205, on the other hand, covers what the law calls inexcusable negligence or ignorance.
Okay, but there is a specific modifier here in the source outline that really caught my eye. It says the judgment must be manifestly unjust.
Yes.
In the previous section, it just said unjust. Why do they add the word manifestly here? What does that change?
It's a huge distinction. It signals a much higher threshold of error. For a judge to be criminally negligent, meaning they go to jail just for being bad at their job, the mistake has to be absolutely egregious.
How egregious are we talking?
The source material quotes a legal authority named Albert, who gives a definition that is honestly a bit of a burn on the offending judge.
Let's hear it.
He says a judgment is manifestly unjust if it is so manifestly contrary to law that even persons with meager legal knowledge cannot doubt the injustice.
Oh, wow. Even persons with meager legal knowledge. That is the Supreme Court throwing some serious professional shade right there.
They're not pulling any punches.
They're essentially saying, you do not need a law degree to know this was wrong. A first-year law student, a guy who watches a lot of true crime documentaries, would know this was wrong.
Exactly. We aren't talking about a judge who slightly misinterprets a highly vague clause in a complicated 50-year-old corporate contract.
Right.
We are talking about a judge who, say, sentences someone to 10 years in prison for an act that isn't even written down as a crime anywhere in the books.
Or a judge who ignores a major law that was literally passed last week just because they couldn't be bothered to read the legal update.
Exactly. It has to be inexcusable.
Let's try another hypothetical here to test the boundaries. Let's say a judge is presiding over a major drug trafficking case. The law clearly says the mandatory penalty for this specific amount of drugs is life imprisonment. No exceptions.
Okay, mandatory life.
But the judge looks at the defendant and decides, you know what? This kid looks really sorry. I think he has potential. I'm going to ignore the mandatory minimum and just give him 6 months of probation.
That would absolutely be manifestly unjust.
Even though the judge was trying to be nice.
Yes. The law leaves absolutely no room for that kind of ruling. The judge does not have the personal discretion to just rewrite the penal code from the bench because they feel sympathetic.
So that's not a difference of legal opinion.
No, that is a judge flatly failing to apply the basic fundamental letter of the law. That qualifies as inexcusable ignorance.
Speaking of that word discretion, this is a phrase that gets thrown around constantly. You hear it in legal dramas, you see it on the news. Abuse of discretion.
Oh, lawyers love to shout that one.
Right. Objection, Your Honor. This is an abuse of discretion. So if a judge abuses their discretion, are they automatically committing a crime under this article, Article 205?
That is a massive misconception. The short answer is usually no, not at all.
Explain that for us. Because the word abuse sounds inherently bad. Abuse sounds like a criminal act.
It does, but in this context, abuse of discretion is really an appellate term. It's the technical argument you make when you want a higher court, like the Court of Appeals, to overturn a lower judge's decision.
So it means the judge acted arbitrarily?
Yes, arbitrarily or whimsically, like they made a call without a solid foundation. But, and this comes directly from the case of Evangelista versus Honorable, Bay's abuse of discretion does not necessarily involve ulterior motives or willful disregard of rights.
So a judge can be totally arbitrary, like they can make a really bad call on whether to allow a surprise witness to testify or whether to grant a lawyer a postponement because they're sick, and the higher court might slap them on the wrist and reverse the decision.
That happens every day.
But the police aren't going to show up and put that judge in handcuffs.
Right. Unless that abuse of discretion was so wildly detached from reality that it crosses the line into that inexcusable negligence we just talked about.
That's rare.
Very rare. The vast majority of abuse of discretion cases are just procedural errors. They are corrected by paperwork, not by sending the judge to the local penitentiary.
It seems like this whole system is really designed to correct errors administratively whenever possible. Like you fire the judge or you overturn the ruling rather than treating them like a bank robber.
That is an accurate way to look at it. Criminal law is meant to be the weapon of last resort. We only use it when the public officer's conduct is so deliberately offensive that it threatens the actual integrity of the state itself.
Okay, so we've covered the final verdict stuff. Guilty, not guilty, life in prison, probation. But anyone who has ever actually been involved in a lawsuit knows that the final verdict is just the very end of a long, incredibly painful road.
A very long road.
What about all the stuff that happens in the middle of the trial? The day-to-day rulings?
The procedural battlefield. Yes, this leads us right into Articles 206 and 207.
All right, Article 206 deals with unjust interlocutory orders. Now, interlocutory is a $5 legal word, if I've ever heard one. I'm guessing most of our listeners do not use that at the dinner table.
Probably not. But simply put, an interlocutory order is a decision that a judge makes that settles a specific issue within the case, but it doesn't end the case itself.
The source outlines a test for this, right?
Yeah.
The Kapisan and Manamangagawa test.
Yes. The test is very straightforward. Does the judge's order leave something to be done regarding the merits of the case?
Meaning, is the trial still going to continue after this order?
Exactly. If the answer is yes, then it's an interlocutory order.
Give us a real-world example so we can picture it.
Sure. Think about a high-stakes murder trial. The defense attorneys desperately want to introduce a private diary that proves the victim was highly suicidal, which supports their theory that it wasn't a murder at all.
And the prosecution obviously objects to the diary being shown to the jury.
Right, so the judge has to make a ruling right there on the spot. Objection sustained or objection overruled.
And that ruling is an interlocutory order.
Precisely. The trial is going to continue either way, but the judge has decided a crucial mid-trial issue.
But that specific ruling could basically decide the entire case. I mean, if that diary is kept out of evidence, the defendant might end up going to jail for the rest of his life.
Which is exactly why Article 206 exists. The law recognizes that a corrupt or negligent judge can completely sabotage a case long before they ever reach the final judgment.
They can essentially rig the game in the middle innings.
Exactly. So if a judge knowingly renders an unjust interlocutory order, like intentionally suppressing that diary because he secretly wants the defendant to lose, he is just as guilty as if he had pronounced a fake guilty verdict at the end.
So the exact same standards apply here as the previous articles. You still have to prove actual malice or that gross, inexcusable ignorance.
Yes. The standards mirror the ones for final judgments. Malice or inexcusable negligence.
Now, let's transition to talk about the one thing that drives absolutely everyone crazy about the legal system: the speed of justice. Or, more accurately, the total lack thereof.
Yes. Article 207, malicious delay.
In many jurisdictions, and specifically in the context of the source material we are reviewing, cases can drag on for 5, 10, sometimes 15 years.
It's a massive systemic issue.
You would think if delaying justice is a literal crime, half the judiciary in the country would be behind bars right now.
You'd think so, but clearly judges are not being arrested en masse for having backlogged dockets.
Why not, if the law says delay is a crime?
Because of the word malicious, the outline notes from the Reyes syllabus are very emphatic on this specific point. They state clearly, mere delay is not criminal.
Mere delay. I have to say that sounds so dismissive to a victim. Oh, don't worry, it's just mere delay that caused me to lose my business while waiting 5 years for a simple permit ruling.
It is incredibly frustrating for the litigant, there's no denying that. But you have to look at it objectively from the judge's perspective.
Okay, let's step into their shoes.
If you are a judge and you have 500 active cases on your docket, and realistically you can only hear maybe 5 cases a day, someone is inevitably going to wait.
The math just doesn't work.
Right. That delay is a systemic failure of infrastructure and funding. It is not a criminal act committed by the individual judge.
So for a delay to actually be a crime,
it must be caused with deliberate intent to inflict damage to litigants.
wow. So you have to prove the judge specifically targeted you with the calendar.
Yes. Let's create another scenario to illustrate this. Imagine a judge is handling a civil dispute involving a massive shipment of highly perishable goods.
Let's say a boatload of bananas sitting in the blazing sun down at the harbor.
Perfect. Millions of dollars worth of bananas, and there is a legal dispute over who actually owns them.
So nobody can move the boat until the judge signs an order.
Right. Now, the judge knows full well that if he doesn't sign the release order by Tuesday afternoon, those bananas are going to rot in the heat and become completely worthless.
And let's add some malice. Let's say the judge knows the owner of those bananas is his biggest political rival in the upcoming local election.
There's the motive. So the judge, looking at a completely empty schedule on Monday, decides to just take the day off and go golfing instead.
Specifically because he wants those bananas to rot.
Yes. He wants to financially ruin his political rival. That is malicious delay.
He isn't just being slow. He is weaponizing the passage of time.
Precisely. But again, think about the burden of proof here. Proving that in court, good luck.
Right, because the judge could just say, I was reviewing other case files at home.
Exactly. Unless the judge literally tells his clerk, watch this, I'm going to go play 18 holes and make him wait until his fruit rots. It is almost impossible to distinguish between malicious delay and I'm just an overwhelmed, tired judge delay.
It really seems like a recurring theme here in this deep dive. The law goes to great lengths to protect the official, unless you can show that black heart, the provable evil intent.
It absolutely does. And that brings us to the next group of people in the system, the ones who actually bring the cases to the judges in the first place.
Right, the enforcers. This is Segment 4, Article 208, negligence or tolerance in prosecution.
This shifts our focus away from the judges on the bench, down to the street level and into the prosecutor's office. This article applies to public officers or officers of the law.
So we are talking about police chiefs, local prosecutors, even barangay officials or village leaders.
Anyone with the duty to enforce the law.
The core crime described here basically seems to be looking the other way.
The legal definition is maliciously refraining from instituting prosecution or tolerating the commission of offenses.
We have some really colorful examples in the source material for this one. Let's talk about the case of People versus Mina. Tell us about the police chief and the Juateng lists.
This is a textbook example of illegal tolerance. Juateng, for listeners who might not be familiar, is an illegal numbers game.
Like an underground lottery.
Exactly, and it's rampant in certain areas, often operating as a sort of open secret in the community. So in this case, People versus Mina, a local chief of police actually caught a Juateng collector.
Like caught him in the act.
Yes. The collector had the physical lists on him, the paper evidence of the illegal bets that had been placed.
So he was caught absolutely red-handed.
Red-handed with the evidence in his pockets. But the chief of police didn't file the case. He didn't institute the prosecution. He just let the guy slide.
Why? Did the court case say why he let him go?
The legal text focuses mostly on the act of tolerance itself. But contextually, in these types of gambling cases, it almost always implies underlying corruption or political protection.
Like the local syndicate was paying off the precinct.
Exactly. The chief essentially decided that the law against gambling didn't apply to this specific guy on this specific day, and the Supreme Court came down hard and said, no, You are an officer of the law. You do not get to unilaterally choose which crimes to ignore. If you tolerate it when you have the evidence, you are criminally liable.
There was another case right next to it in the notes, U.S. versus Mendoza. This one involved a barrio lieutenant and an arsonist.
Same exact principle, just a different crime. A house was burned down. The barrio lieutenant, which is basically the village chief or local authority, was formally informed about it. He knew exactly who started the fire.
And he did nothing.
Nothing at all. He didn't report it to the higher authorities, didn't initiate a complaint. He was held fully liable for dereliction of duty.
So the overarching message here is, if you wear a badge or hold an office, you cannot just be a passive bystander to a crime.
Generally speaking, yes, that is your duty. But there are always exceptions in the law.
Always.
And the source points out a fascinating little bureaucratic loophole regarding taxes.
Yes, the Internal Revenue exception. I saw this in the notes and had to read it twice. It says, if an IRS agent or a tax revenue officer catches someone evading taxes and just ignores it, they aren't punished under this penal code article.
Right. If a tax officer sees a blatant tax violation and actively ignores it, they are punished under the specific National Internal Revenue Code, not Article 208 of the Revised Penal Code.
Why make that distinction? Is it a lighter penalty if you get charged under the tax code?
Not necessarily lighter or heavier. It's just a fundamental principle of how statutes work. Special laws always prevail over general laws.
So the penal code is the general rule.
Yes, and the tax code is a highly specialized law, so it contains its own specific disciplinary measures for its own officers. It's really just a matter of jurisdiction. But for you, the listener, the ultimate takeaway is the same. The corrupt tax officer is still going to be in major trouble. They're just going to be tried in a different courtroom under a different book.
Okay, that makes sense. Now, let's talk about something that I think deeply confuses a lot of the general public. Prosecutorial discretion.
A very hot topic.
We see this on the evening news all the time. Someone files a massive public complaint against someone else, and the prosecutor just dismisses it. They issue a statement saying lack of probable cause.
Happens constantly.
And the victim is usually on the courthouse steps screaming, "Dereliction of duty! The prosecutor is ignoring the crime!"
This is exactly the battlefield of the Vita Bagatua versus Revilla case mentioned in the syllabus. The court really had to draw a hard line here. They explicitly ruled that a prosecutor is not legally compelled to file a criminal charge in court just because a citizen filed a complaint.
But doesn't that give the single prosecutor way too much power? I mean, if I come to your office with evidence that my neighbor physically assaulted me, and you just look at it and say, I don't feel like taking this to trial, aren't you completely blocking my access to justice?
But it's never, I don't feel like it. It has to be based on an evaluation of the evidence. The prosecutor acts as a necessary filter for the court system.
Because there are too many cases.
Way too many. Think about it. If every single citizen complaint, no matter how crazy, vindictive, or legally weak, automatically went to a full jury trial, the courts would completely collapse in a week.
We'd be doing trials over stolen lawnmowers for 20 years.
Exactly. The prosecutor has the legal duty to look objectively at the evidence and ask, is this enough proof to actually win a conviction? If the answer is no, their duty is actually to drop the case.
So refusing to file a weak case isn't dereliction of duty. It's actually just doing the job properly.
Exactly. It's protecting the court's time and protecting citizens from baseless trials.
But here is where my skepticism as a host has to kick in.
Let's hear it.
What if the prosecutor says to the press, the evidence is weak, but actually, behind closed doors, they just took a massive bribe from the suspect's lawyer?
There's that word again, malice.
It always comes back to malice.
The case of People versus Malabanan tells us that malice in prosecution requires deliberate evil intent. You have to prove that the prosecutor dismissed the case not because of a genuine belief the evidence was weak, but because of some external corrupt factor.
And there's another incredibly interesting layer to this protection for the enforcers, right?
Yeah.
The underlying crime doctrine. This one's a bit of a brain twister when you first read it.
Yes, going back to U.S. versus Mendoza, the court established a vital logical rule. They held that to legally prove dereliction of duty for failing to prosecute a crime, the underlying crime itself must be proven to have actually happened.
Okay, walk me through this slowly. Let's say I'm walking down the street and I see a guy, let's call him Bob, running out of a house carrying a giant flat-screen TV.
Okay.
I run up to a police officer on the corner and yell, "Officer, Bob just stole that TV." But the cop just ignores me and keeps drinking his coffee.
Right.
So I get mad and I sue the cop for dereliction of duty, for tolerating a robbery.
In your trial against that cop, you first have to prove to the court that Bob actually stole the TV.
Wait, really?
Yes. Because what if it turns out during the investigation that it was actually Bob's own house and it was his own TV and he was just moving out in a hurry?
Then there was no theft.
Exactly. And if no crime of theft actually occurred in reality, the police officer cannot possibly be found guilty of failing to prosecute a theft.
Even if the cop thought it was a theft at the time and just lazily ignored it anyway.
Yes. You cannot be held criminally liable for tolerating a phantom crime. It's a logical safety valve built into the law. You can't be punished for failing to stop something that didn't happen.
Wow. Okay, one last point on the enforcers before we move on. What if they don't just lazily ignore the crime? What if they actively help the bad guys?
Active betrayal. Article 208 has a specific provision for this. It applies if the officer harbors, conceals, or assists in the escape of the offender.
Like the classic movie trope of the dirty cop driving the getaway car from the bank robbery.
Or the prison guard who accidentally leaves the back door of the maximum security cell unlocked at midnight. If an officer does that, they are punished as a principal in the crime of dereliction. But you have to notice the careful distinction the law makes here from the crime of bribery.
Right, because if I pay the prison guard 50 grand to unlock that cell door, that's bribery.
Which is covered under Article 211A, a different section.
Ah.
But what if the guard unlocks the door because the prisoner is his cousin? Or because a local politician secretly called him and told him to do it, and no actual cash changes hands?
That's where Article 208 catches them.
Exactly. It is designed to catch the systemic corruption and favoritism that doesn't involve a paper trail of cash.
Okay, we've done the judges up high on the bench. We've done the cops down on the street. Now let's talk about the people we actually pay to save us from both of them.
The lawyers.
Segment 5, Article 209.
Betrayal of trust by an attorney.
I have to say, this one feels the most personal to me.
It does.
Because when you hire a defense lawyer, you are almost always at your absolute lowest point in life. You are terrified. You might be facing jail. You're financially strained.
You're completely exposed.
You literally have to tell them things you wouldn't even tell your own spouse. Your deepest secrets.
And that extreme vulnerability is exactly why the law treats the violation of that trust as a severe criminal act. The attorney-client relationship is entirely sacred in the legal system.
It has to be.
If people are afraid to be completely honest with their own lawyers because they fear betrayal, they cannot possibly get a fair defense. The system breaks.
Article 209 gives us 3 very specific ways a lawyer can go to prison for betraying that trust. Let's take them one by one. Number 1 on the list, causing damage to the client by inexcusable negligence or ignorance.
Now, this should sound very familiar. It sounds a lot like the rule for judges we discussed in Article 205, doesn't it?
It really does. It's the standard incompetence clause.
But there's a very key phrase included here that changes everything, causing damage.
Okay, let's test that with a hypothetical. Say I hire a lawyer for a civil trial, and he is just terrible.
The worst lawyer in town.
Right. He shows up late to court every day. His suits are wrinkled. He constantly forgets to object when the other side breaks the rules. He literally spills hot coffee all over my key evidence.
It's a total disaster.
But despite all of that, maybe the jury just really likes me. Or the other side's case happens to be incredibly weak and I end up winning the lawsuit anyway. I get my money and walk free.
In that scenario, there is absolutely no crime committed under Article 209.
Wait, none. Even though he was awful.
None. You cannot sue him for criminal negligence because you were not legally damaged by his actions. You won. You might be incredibly annoyed, and you should probably refuse to pay his bill, but you are not a victim in the eyes of the penal code.
So professional incompetence is only a crime if it actually tangibly hurts the client's outcome.
Right. Actual prejudice to the case is required for it to be a crime.
Okay, let's move to number 2. This is the juicy one. Revealing any of the client's secrets learned in a professional capacity.
This is the classic breach of privilege.
Now, let me ask the obvious question based on the last rule. Does this one require the client to suffer damage?
No. And that is the massive difference between the two clauses.
Wait, really? Let's play this out because that's fascinating. I hire a lawyer, and in confidence, I tell him, look, I have a secret underground collection of vintage Pokemon cards.
Okay, very secretive.
And it has nothing to do with my trial. But my lawyer goes to a fancy cocktail party that weekend, gets a little drunk, and tells everyone there, hey, you know my new client, the guy on trial. He loves Pokemon cards.
Okay.
Now, that revelation doesn't hurt my court case at all. I don't lose any money. It's just deeply embarrassing for me socially.
Well, technically speaking, that is a crime under Article 209.
Just for that.
Yes, because the betrayal of the confidence is the actual offense. The law presumes that the mere revelation of a secret itself is the injury.
That is incredibly strict.
Now, practically speaking in the real world, will a district attorney actually charge a lawyer with a felony for the Pokemon story? Probably not. They have bigger fish to fry.
Right.
But if the lawyer reveals, my client told me in private that he was actually at the scene of the crime that night, even if the prosecutor ultimately doesn't use that information in court, the lawyer has absolutely committed a felony.
Because if clients can't trust that their lawyer's silence is absolute and unbreakable, they will just stop talking.
Exactly. The damage isn't just to the individual client, the damage is to the entire institution of legal defense.
That brings us to number 3. Undertaking the defense of the opposing party in the same case without the consent of the first client.
The double cross. Or, in formal terms, conflict of interest.
This feels like something out of a bad television show. How does a professional lawyer actually end up representing both sides of the exact same fight?
It happens much more often than you'd think, actually, especially in complex civil cases or really messy corporate divorces.
Yeah. How does it start?
Say a lawyer starts advising the husband in a divorce on how to hide his assets. Then, 3 months later, the wife comes into the same firm looking for representation, and the lawyer, maybe out of greed for more billable hours, or maybe just out of sheer administrative forgetfulness, takes her case too.
So the lawyer already knows the husband's entire secret strategy.
Yes.
And now he's officially representing the wife, using those secrets to help her defeat the husband.
That is the core of the crime. The statute calls it double bealing. You are using the confidential secrets of client A to actively help client B defeat client A. It is considered the ultimate betrayal in the legal profession.
Look, but there's a massive loophole written right into the outline here. It says, without the consent of the first client.
Yes. Consent completely cures the conflict of interest.
But who in their right mind would ever consent to that? Sure, Mr. Lawyer, take all my deepest secrets and use them against me in court. Sounds great.
Well, it usually happens in highly amicable settlements.
Okay.
Say a couple wants a really quick, painless annulment, and they agree on everything. They might mutually agree to just use one single lawyer to draft all the paperwork for both of them, just to save thousands of dollars in legal fees.
So they waive the conflict.
Right. If the husband signs a paper that says, I consent to you also advising my wife for this limited purpose, then the lawyer is entirely in the clear criminally.
But if things suddenly get nasty later on,
then the lawyer has to be very, very careful and usually has to drop both of them to avoid jail time.
before we wrap up the lawyers, one little historical detail caught my eye in the source notes. The article mentions punishing attorneys or solicitors.
Ah, yes. That's a bit of a ghost from the Spanish colonial era.
What exactly is a solicitor in this context? Because I hear that term in British shows all the time.
Right. In the old system and currently in the UK, there is a formal split in the legal profession. You have barristers, who are the ones who put on the wigs and argue in front of the judge in court. And you have solicitors who do all the behind-the-scenes paperwork, draft contracts, and meet with clients.
So why is it in this code?
Well, the Philippine Penal Code we are studying was drafted back in the 1930s, and it was heavily based on much older Spanish penal codes, so it explicitly mentions procurador judicial, which translates to solicitors.
But do we actually have them now in the modern courts?
No. The Reyes notes clarify that under the modern revised rules of court, the profession is totally unified. Once you pass the bar, you are an attorney at law. You do both the paperwork and the talking.
So it's an outdated term?
Yes. The term solicitor sitting there in the penal code is effectively a legal fossil. It doesn't really apply to anyone practicing today, but it hasn't been scrubbed out of the text either.
I genuinely love those little legal fossils. It really reminds you just how old these rules are.
It does. And it shows that the core human problems, the betrayal, the gross negligence, the greed and corruption, those haven't changed a bit in over 100 years.
So we have surveyed the entire landscape of this chapter. We have looked at the judges, the prosecutors, the police chiefs, and the private lawyers. We've seen the very specific, defined lines they have to cross to go from being public servants to being convicted criminals.
And we have definitely seen the pattern emerge across all of them.
The pattern is what really bothers me at the end of this deep dive. Because reading through all these cases, it feels like the whole system is heavily rigged to give the ultimate benefit of the doubt to the people who already hold all the power.
I think rigged might be too strong of a word. I would describe it as insulated.
Insulated. Okay, that's a very polite, lawyerly way of saying it is nearly impossible to put a bad judge or a lazy cop in jail.
It is incredibly difficult, yes. But you have to consider the alternative reality.
What's the alternative?
If we dramatically lowered the bar for these crimes, if we made negligence super easy to prove by removing the manifestly part, if we entirely removed the requirement to prove malice from the prosecutors,
We would have absolute chaos. We would have witch hunts.
we would have endless witch hunts. Every single time a prosecutor lost a high-profile, emotionally charged trial, the angry public would demand he be arrested the next day for a dereliction of duty.
Yeah, the losing side would always want blood.
Every time a judge made a slightly controversial ruling on a hot-button political issue, the losing political party would immediately file criminal charges against her.
The justice system would just turn into a circular firing squad.
Exactly. Nobody would be doing any actual legal work. Everyone would just be busy arresting everyone else.
So that incredibly high bar for conviction, that absolute necessity to prove deliberate evil intent, that is basically the steep price we pay for systemic stability.
Exactly. It is a necessary trade-off. We as a society basically accept the uncomfortable fact that some incompetent or mildly corrupt officials are inevitably going to slip through the cracks in exchange for having a system that allows the honest officials to actually do their extremely difficult jobs without constant paralyzing fear.
That is the logical structural answer. But man, it is a very hard answer to swallow if you are the innocent person who just became the victim of that mild corruption.
It is deeply unsatisfying on a personal level, and that is exactly why doing these kinds of deep dives into the source material is so important.
Because it demystifies it.
Right. Knowing the actual letter of the law helps you understand why a specific, frustrating outcome happened in court, even if you passionately hate that outcome.
So here is the provocative final thought I want to leave with all of you listening today. We started this hour by asking, who watches the watchmen?
And the answer seems to be the law watches them.
Right. But based on everything we've read today, the law is watching them through a telescope that is set to a very, very specific focus.
It is exclusively focused on malice.
Exactly. It completely ignores the blurry edges of incompetence. It ignores the gray areas of subconscious bias or laziness. It only fires its weapon when it sees pure, concentrated, undeniable evil intent.
Or pure, concentrated, undeniable stupidity.
True. So the big question you have to ask yourself is that standard still enough?
It's a fair question.
In a modern world that is getting vastly more complex every day, where corruption is getting more sophisticated and harder to trace, is malice still the right metric? Or is it finally time for the watchman to be held to a much higher standard of baseline competence where, oops, I just didn't know the law, is simply no longer an acceptable excuse to stay out of prison?
That is going to be the central debate for the next entire generation of legal reformers.
Definitely something to chew on the next time you see a judge's gavel bang down. Thank you so much for joining us on this incredibly detailed deep dive into the dereliction of duty under the revised penal code. Stay curious, stay appropriately skeptical of power, and we will catch you on the next one.
Thanks for listening. Goodbye.
Welcome to The Debate.
Yeah, glad to be here.
Imagine a signature, just a bit of ink on paper. Most of us, we sign credit card receipts, birthday cards, maybe a lease. But for a select few, the judges sitting on the bench and the prosecutors standing at the bar, that signature carries a weight that is almost impossible to quantify. That ink can strip a person of their property, ruin their reputation, or, well, take away their liberty for the rest of their natural life.
Right. It is the ultimate power. It is essentially the state's monopoly on violence delegated to a human being in a black robe or suit. And the terrifying reality is that human beings are flawed. They get tired, they get biased, and sometimes, frankly, they get corrupted.
And that is exactly the heavy subject we are dissecting today. We are looking at Article 204 through Article 209 of the revised Penal Code, dereliction of duty. We are not talking about the criminals in the dock today. We are talking about the people running the courtroom. The central question we really need to answer is this. When they get it wrong, horribly, catastrophically wrong, does the law actually hold them accountable? Or is the system rigged to protect its own? I represent the view that the law strictly and correctly differentiates between human error and criminal intent to preserve the justice system.
And I take the opposing view. I argue that the definitions of inexcusable negligence and malicious tolerance create dangerous gray areas that effectively shield incompetence and subtle corruption.
Let's get right into the position statement. I want to lay the groundwork for why the law is written this way, because it isn't accidental. It is a necessary protective measure for the institution itself. Judicial and prosecutorial immunity from criminal liability for mere error is the absolute bedrock of a functioning justice system. The cornerstone here is Article 204, knowingly rendering unjust judgment. Now, the key word, the operative word, is knowingly. The Supreme Court has been very explicit here. In Stamaria versus Ubai, they established that for a judge to be criminally liable, it is not enough that the decision was wrong. It is not even enough that it was contrary to law.
Which sounds insane to a layperson. I mean, if a judgment is contrary to law, isn't it by definition unjust?
Unjust in effect, perhaps, but not criminally unjust in intent. Judges are human. They interpret complex, often conflicting realities and statutes. The standard requires evidence of conscious and deliberate intent to do an injustice. We are talking about ill will, revenge, bribery. If a judge interprets the law incorrectly but does so in good faith, that is an error for the appeals court to fix, not a crime for the penitentiary. Just look at U.S. versus Gaquitan. The accused was acquitted even though the judgment was flawed, precisely because there was no proof he knew it was unjust. That distinction is the firewall that keeps the judiciary independent.
So you call it a firewall, but I call it a blindfold. My position is that the requirement for deliberate intent creates a massive loophole. You are relying on Article 204, but I want to pivot to Article 205, judgment rendered through negligence. The standard here is that the judgment must be manifestly unjust. The Albert case defines this as something so contrary to law that even persons with meager legal knowledge cannot doubt the injustice. But if the injustice is so obvious that someone with meager knowledge can spot it, why is it so incredibly rare to see a conviction? You mentioned Gaitan as a defense of the system. I view it as an indictment. It suggests that a judge can be functionally incompetent, completely ignorant of the basic laws they are sworn to uphold. But as long as they aren't evil, as long as they are just clueless, they are safe. The victim is still in jail, but the judge sleeps soundly because he didn't have malice.
That is a nice rhetorical flourish, but I think it misses the legal reality. Let's dig into this manifestly unjust concept for our first segment. You are blurring the line between incompetence and discretion.
I don't think I am. I think the law blurs it to protect the judge.
Well, look at Yadaranyan versus Judge Rubio. This case is critical to understanding these protections. It ruled that an error of judgment cannot be the basis for a criminal charge in the absence of bad faith. Think about the alternative here. If every time a judge was reversed on appeal, they faced a criminal investigation for inexcusable negligence, the courts would completely freeze. No one would ever issue a controversial ruling.
Right, but there's a massive gap between a controversial ruling and a manifestly unjust one.
But who decides that gap? That is the problem.
The law tries to, but then it immediately muddies the water. Take Evangelista versus Han Baez. It says abuse of discretion doesn't necessarily involve ulterior motives. So a judge can abuse their power, ignore the rights of a litigant, but if they claim they thought they were doing the right thing, they just walk away. It feels like we are prioritizing the judge's comfort over the litigant's rights.
We aren't prioritizing comfort. We are prioritizing the finality of law without the constant threat of imprisonment hanging over the bench. But you brought up an interesting point earlier about the types of judgments. It's not just the final verdict that matters here.
Exactly. Article 206 covers unjust interlocutory orders.
And for our listeners, let's quickly clarify interlocutory orders. These are the decisions made during the trial, granting a postponement, allowing a piece of evidence, procedural steps. Not the final verdict that sends someone to jail, but the steps to get there.
Right, the appetizer before the main course. But these orders can absolutely starve a litigant. You can delay a case for 10 years with interlocutory orders. The law says these must be knowingly unjust or result from inexcusable negligence. But then you have cases like Kapasanan Neng Mangawaga, which distinguishes these from final judgments. It creates this gray zone where a judge can bleed a litigant dry with procedural delays And because it isn't a final judgment, the scrutiny is actually lower.
You are conflating administrative failure with criminal intent again. The law does punish these acts, but it requires rigor. You seem to want a system that punishes stupidity or inefficiency with jail time. The penal code is designed to punish criminality. There are administrative bodies to fire bad judges. We are talking about putting them in handcuffs.
I want a system where inexcusable ignorance, which are the law's own words, actually has consequences. If a doctor displays inexcusable ignorance during surgery, it is criminal negligence. If a driver displays it on the highway, it is reckless imprudence. But a judge? It's just judicial discretion.
It is different because the judge is an arbiter, not an operator. But let's pivot. We have spent enough time on the bench. Let's look at the people standing before the judge, the prosecutors. This is where your theory about protecting their own really gets tested.
Oh, this is where it falls apart completely.
We are talking about Article 208, negligence and tolerance in prosecution.
Ah, yes. The thin blue line that turns into a stone wall. This article is supposed to punish officers of the law who maliciously refrain from prosecuting crimes or tolerate the commission of offenses.
And it works. The source material cites People versus Mina. A chief of police caught a Jutang collector, illegal gambling. He had the lists, he had the collector, and he didn't file the case. The court nailed him. He was held liable for dereliction of duty. That is a clear, documented win for accountability.
Yeah, but that is the low-hanging fruit. A cop protecting a gambling lord is easy to spot. It's blatant. But look at the case law for the actual prosecutors, the lawyers. Vida de Bagatua versus Revilla. This case essentially hands prosecutors a get-out-of-jail-free card.
It safeguards their discretion. You cannot have a prosecutor who operates like a robot.
The ruling says a prosecutor is not under compulsion to file charges if they are not convinced by the evidence.
Which is entirely sensible. Imagine if a prosecutor had to file every single complaint that crossed their desk, no matter how flimsy or vindictive. You would be dragging innocent people into court constantly. The prosecutor acts as a filter. They must evaluate the evidence.
I agree they need a filter, but Vita de Bagatua makes the filter totally opaque. If a prosecutor has been bribed to kill a case, men say, I am dropping this because I took a payoff. They say, in my professional judgment, the evidence is insufficient. And the court says, okay, we respect your discretion. It is the perfect hiding spot for malicious tolerance.
You are assuming corruption where the law assumes regularity. You need proof. People versus Malabanan defines the malice required here. It needs deliberate evil intent. You have to prove the prosecutor intended to favor the criminal. You can't just guess that they were bribed.
But proving that intent is made literally impossible by the absolute wildest catch-22 in this entire document. U.S. versus Mendoza.
I had a feeling you were going to bring that up. It is a highly technical point, but a valid one to debate.
It is not just technical. It is a masterclass in circular logic. U.S. versus Mendoza states that a prosecutor cannot be liable for dereliction of duty if the guilt of the alleged law violator is not proved.
Correct. You cannot be guilty of failing to prosecute a crime if no crime was committed. That is basic fundamental logic.
But think about the practical application of that logic. Who is responsible for proving the crime was committed in the first place?
The prosecutor.
Exactly. So if a prosecutor is lazy, incompetent, or corrupt, and they do a terrible job presenting the evidence, the criminal gets acquitted. Because the criminal is acquitted, the law says, well, his guilt wasn't proved. And because the guilt wasn't proved, the prosecutor can't be charged for failing to prosecute him. The prosecutor's own failure becomes their absolute defense.
I see where you're going. It sounds like a paradox on its face.
It is a paradox. It's a self-cleaning oven for corruption. If I am a barrio lieutenant, to use the text's own example, and I let my friend the arsonist go, and he is never convicted because I hid the evidence, I am safe because his guilt was never duly proven.
That is a very cynical reading, but I admit, logically, it is a tight loop. However, the alternative is much worse. If we allow prosecutors to be criminally charged every time they lose a case, we are essentially trying the case twice. We cannot have a system where we say the court acquitted him, but we secretly know he did it, so the prosecutor is in trouble. That completely undermines the verdict of the court.
It doesn't undermine the verdict. It exposes the sabotage of the process.
The remedy there is specific statutes. The text mentions internal revenue officers have their own strict liability laws. Article 208 is a catch-all. It is not meant to micromanage every single failure. You are asking the Penal Code to solve personnel and administrative problems.
I am asking the Penal Code to punish people who facilitate crime by looking the other way.
Let's move to the final piece of the puzzle, the private lawyers, and specifically the issue of delay and betrayal. This touches on Article 207 and 209.
Right. Article 207, malicious delay in the administration of justice.
This is vital for the reality of our courts. We all know the backlogs. Our courts are flooded. Article 207 clarifies that mere delay without malice is not criminal. To send a judge to jail for delay, you must prove deliberate intent to inflict damage.
Which, again, just protects the lazy. A judge can sit on a case for 2 years just because they prefer golfing to writing decisions. Unless I can prove he specifically hates me and wanted to hurt me, he is not criminally liable. He is just slow.
And he should be fired for that, or have his pay docked, but not imprisoned. There's a profound difference between being a bad employee and being a criminal.
Fair enough. But let's look at Article 209, betrayal of trust by an attorney. This is where I found a fascinating contradiction in what the law actually values. This one really stuck with me.
Go on.
Article 209 penalizes two distinct things: causing damage to a client through negligence and revealing a client's secrets.
Right. Malpractice and breach of confidentiality.
Now, for negligence, being an idiot lawyer who forgets to file the appeal, the text says damage to client is essential. If I make a huge mistake but you get lucky and win anyway, I haven't committed a crime. No harm, no foul.
Logical. The crime is the injury.
But for revealing secrets, the text explicitly says damage to client is not required.
Because the breach of confidence is the harm.
Exactly. But look at the implication there. The law values the secrecy of the guild more than the competence of the professional. I can be inexcusably negligent and jeopardize your entire life, but if you happen to survive it, I am fine. But if I whisper your secret at a cocktail party, even if it hurts no one, even if you win your case, I am a criminal. It protects the omerta of the legal profession more fiercely than the quality of the defense.
I disagree completely. It protects the relationship. If you cannot trust your lawyer with the absolute truth, the entire adversarial system collapses. You wouldn't tell me where the body is buried, metaphorically speaking, if you thought I might slip up without consequence. The law punishes the betrayal of the soul, the secret, more than the clumsiness of the hand.
That is very poetic. But if I am the client, I would rather you keep my secret and not lose my case because you forgot to file a basic motion. I feel like the law treats negligence as a whoops moment while treating secrecy as sacred.
We all want perfect lawyers, but we're discussing criminal statutes here. Look at the other betrayal in Article 209, defending the opposing party.
Conflict of interest.
It is strictly forbidden unless the first client consents.
Right. No crime where first client consents, which treats the justice system like a private transaction. If you guys are cool with it, the court is cool with it. But isn't there a massive public interest in ensuring lawyers aren't playing both sides?
It respects the autonomy of the client. If you are okay with it, the state shouldn't step in like a nanny and say, "No, you're being betrayed." We treat citizens as adults who can waive their rights.
Or it respects the power of the lawyer to manipulate a desperate client into signing a waiver. Look, I can help you, but I needed to sign this form saying it's okay that I also represent the bank foreclosing on your house.
You really view the legal profession as a den of wolves, don't you?
I view them as people with immense power and very little functional oversight. When I read People versus Mina or U.S. versus Mendoza, I don't see abstract legal theories. I see real people abusing their positions and the law shrugging its shoulders.
And in Mina, the system worked. The police chief was punished. The system can catch the wolves.
Only the wolves that are dumb enough to leave a paper trail. The smart ones hide behind discretion and insufficient evidence.
Well, as we wrap up, I think we have clearly illuminated the central friction here, and it is certainly not going to be solved today. My position stands. Articles 204 through 209 are meticulously designed to uphold the presumption of regularity. We punish the corrupt heart, bribery, deliberate malice, the intent to harm. If we lower that standard, we rule by fear, and a fearful judiciary is a useless one.
And my position remains that while the law punishes the corrupt heart, it turns a blind eye to the willfully blind eye. By requiring proof of knowledge and protecting discretion at all costs, we create a sanctuary for incompetence and subtle corruption.
It is a delicate balance. To criminalize ignorance is a very heavy step.
But to excuse inexcusable ignorance, which is the actual legal term used in the text, is a tragedy for the person standing before the bench.
A final reflection for our listeners. Is inexcusable ignorance in a judge functionally different from malice for the person wrongly imprisoned? The law says yes. The victim might say no.
Read the cases, check the statutes, and ask yourself if you would really feel safe with these protections.
Thank you for joining us on this deep dive into the revised penal code.
Until next time.
This has been The Debate.